Hello friends, we are going to discuss today about the arbitration agreement as defined under the Arbitration and Conciliation Act. The arbitration agreement is defined under section 7 of this act, and what is the need of arbitration agreement and what is its importance and what are its features and elements are clearly mentioned in this act under section 7. The very importance of the arbitration agreement, we can say it is a edifice of arbitration process and the arbitration mechanism. Without arbitration agreement, we cannot start or commence the arbitration procedure, and the arbitration can never be held without there being an arbitration agreement. Ultimately, what is this arbitration agreement? It is, however, having the spirit and nature of the contract and agreement what is defined under the Indian Contract Act 1872. However, it fulfills all the features and all the elements of the contract as defined in the Indian Contract Act. Now when it comes to the Arbitration Act, the parties should have arbitration agreement before they refer their dispute to arbitration. Now, in a very commercial dealing, in a very commercial transaction, the parties will obviously have a written document, a written contract, wherein the two parties will have various terms and conditions, and they agree, they consent, they assent to perform those terms and conditions, to honor those rights and obligations against each other, and that is the very purpose of contract. When this contract is breached, when the parties do not perform, either of the parties does not perform, then the other party who is aggrieved, who is injured, who is suffered in this contract may wish to refer this matter to arbitration for resolution of his dispute. Now in this, the very edifice of this arbitration process is arbitration agreement. It is defined under section 7 of the Arbitration and Conciliation Act 1996. It says the arbitration agreement can be in a form of a clause in the contract, or it may be a separate agreement. It must be in writing. It must be signed by the parties. The parties shall be competent to enter into this arbitration agreement, and the very important is the arbitration agreement shall be in writing, and it elaborated the meaning as to when and how it is considered that an arbitration agreement is in writing. It is in writing if it is contained in a document or any exchange of letters, telephone, telegram, telex, or it may also take place through the electronic document, electronic media, electronic communication. Before 2015, this electronic form of communication was not there in this section 7. After 2015 amendment to this act, the electronic form of communication is also constituting the valid arbitration agreement. And if it contains in any of these, either telegram, telex, or the email or any form of electronic communication, it is considered as if it is in writing. And not only the document is in writing, it is also considered as a written arbitration agreement when in the exchange of statement of claim and statement of defense between the parties, if it is alleged by one party and not denied by the other party, is also considered as a arbitration agreement. Now, this arbitration agreement shall be entered into by parties who are competent. The competency of the parties is well defined in the Indian Contract Act. Of course, we are not discussing about the capacity and competency of the parties at this point of time. With reference to this arbitration agreement, what is important is it should be in writing, it should be signed by the parties, and various forms of arbitration agreements like what I said now, it may be in the form of a telex, it may be in the form of a telegram, it may be in the form of a electronic communication, it may be in the form of exchange of letters, exchange of emails, so on and so forth. So these are all the forms which are recognized as the existence of the arbitration agreement between the parties. Now, without this arbitration agreement, the arbitration proceedings cannot take place. You need to have arbitration agreement to refer the dispute to arbitration process, to refer the dispute to the arbitrator. Now, again, I am repeating that this arbitration agreement, it need not be a separate agreement. It can be in a separate clause. It can be a separate agreement, and it can be a part of the main contract. And also, the arbitration agreement can be a reference to external document. That means in the main contract, the parties make a reference that a particular external document having the arbitration clause shall form the part and parcel of this main contract. It is when the existence of arbitration agreement is considered as a written arbitration agreement between the parties, and it is valid and binding between the parties. In that event, when any dispute arises, it is not only the future dispute, it is not only the present dispute, the future disputes also can be referred to arbitration. The definition under section 7 clearly says any dispute that has arisen or that may arise between the parties out of any terms and conditions of this contract which is entered out of the legal relationship and the dispute whether contractual or not. That means the parties have entered into a main business contract, and in this business contract they have arbitration agreement within, or the arbitration clause within the main contract, or a separate arbitration agreement as an annexure to this main business contract. In the main business contract, the parties may have many terms and conditions related to their performance, their execution, their business, trade, so on and so forth. If there arise any dispute A dispute need not be a single dispute. Dispute may be multiple disputes. There may be two disputes, there may be four disputes, there may be three disputes. Now, out of these disputes which have arisen, when the dispute is made out by any of the parties to this contract, that party refers the dispute to arbitration. At this point of time, he may refer all the disputes which have arisen, or he may refer any number of the disputes which have arisen. For example, there arose three number of disputes between the parties. Mr. X alleges against Y of three number of disputes. X may refer three number of disputes to arbitration, and it is his prerogative. He may also refer only one out of these three disputes to arbitration. It is the will and wish, it is the prerogative of the parties as to how many disputes the party refers to arbitration. He may refer one, he may refer two, he may refer all the disputes. Now, the section 7 further defines that the disputes which have arisen between the parties may not be contractual always. They may be non-contractual disputes also. Section 7 recognizes non-contractual disputes also for referring to the arbitration. What are those disputes? Non-contractual disputes may be infringement of intellectual property rights, infringement of trademark, infringement of copyright, infringement of patent rights, or any tortious act also may take place between the parties, and any tortious act also, any tort, action for the tort is also a subject which can be referred to the arbitration for resolution of the dispute. We know very well the action for the tort is not a contractual dispute. However, when it is out of the legal relationship, when it is out of the defined legal relationship between the parties, such action for the tort can also be referred to arbitration. And this is what is there in section 7, that a dispute arising out of a defined legal relationship, whether contractual or not. So this is the edifice, this is the crux in the mechanism and the process of arbitration, that arbitration agreement has to be there before the dispute is referred to arbitration, before the dispute is referred to the arbitral tribunal, before the dispute is referred to the arbitrator. Now, there need not be a pre-drafted arbitration agreement or arbitration clause before a dispute arises. As and when the dispute arises, the parties may very well sit and negotiate. The parties may very well agree, consent for drafting a fresh arbitration agreement or arbitration clause, and once the arbitration agreement is reached between the parties, that gives way to reference of that dispute to the arbitration. That means it is a practice in all the corporate transactions, corporate dealings, commercial transactions, any agreement or contract entered into by the companies or corporate houses. It is always the practice that the corporate houses, corporate companies enter the arbitration agreement or clause in their business contracts from the beginning. However, even when the parties have not entered this arbitration agreement in their business contracts, when the arbitration agreement is absent in the business contracts, even then also the parties may very well refer the dispute to arbitration. However, after the dispute has arisen, when it is made out between the parties, any of the parties, the arbitration agreement or clause can be entered into afresh, and that gives way to reference of the arbitration mechanism, arbitration process. Now, what are the elements and what are the features of this arbitration agreement? Arbitration agreement always should contemplate the very intention of the parties to refer the dispute to arbitration mechanism. If the parties have any slightest doubt, if the parties have any slightest small doubt about their intention, the parties having uh, uncertainty whether they wish to refer the dispute to arbitration or not, that is not an arbitration agreement. The parties' intention shall be certain when they enter into arbitration agreement. Certainty about what? Certainty about reference of their present or future disputes to arbitration process or mechanism. This is what is there in section 7 of the Arbitration and Conciliation Act 1996. Now, it is all the skill of the draftsman who drafts this arbitration clause or agreement, that whenever the arbitration agreement is drafted, they should draft that ensuring the certainty of intention of the parties to refer their dispute to the arbitration. Mere agreeing for amicable settlement is not an arbitration. Mere agreeing to agree to refer to arbitration is not an arbitration agreement. That means the both parties should have concurred, finally determined their intentions, and which should have been contemplated in the form of arbitration agreement to refer their dispute to arbitration. So finally, the certainty of intention to refer the dispute to arbitration is very important. When it is doubtful, when it is vague, when it is unclear, and when it is ambiguous, then arbitration is not possible because the arbitration agreement has not taken place. This is what is the main element of arbitration agreement as explained under section 7. We have different case laws held by the Honorable Supreme Court of India, and we have one case, KK Modi versus KN Modi. In this case, the Supreme Court has given what are the attributes of arbitration agreement. And we have one more different case, that Jagdish Chandar versus Ramesh Chandar in the year 2007, where the Supreme Court of India has clearly discussed as to what are the elements of the arbitration agreement. We have another case, Powertech Worldwide Limited versus Delvin International General Trading. This is also a case held by the Honorable Supreme Court of India about the features and the elements of arbitration agreement. Thank you.